The claim I will be responding to is that the death penalty is counterproductive. The advocate's secondary claims are: 1, the death penalty is unconstitutional and violates the Eighth Amendment; 2, the people who are executed may be innocent; and 3, the death penalty uses substantial law enforcement resources. Back to the first claim, that the death penalty is unconstitutional and violates the Eighth Amendment. The advocate does not give sufficient explanation as to the reasoning behind this claim. The evidence used is insufficient. While the advocate does describe the methods of execution as well as what the Eighth Amendment is, there is no actual connection between the two. The advocate does not describe how the death penalty violates the Eighth Amendment. He simply defines what they are. In addition to this, the advocate uses a quote from the Declaration of Independence, but again does not explain how this quote shows that the death penalty is unconstitutional. According to John D. Bessler, Associate Professor at the University of Baltimore School of Law, since the mid-1970s, the court has read the 8th and 14th Amendments to prohibit the execution of the insane, juvenile offenders, the mentally retarded, non-homicidal rapists, and those who neither kill nor attempt or intend to kill. Even as it has restricted the death penalty's use, however, the court has upheld the death penalty's constitutionality as a general matter and allowed death sentences for those who kill or show a reckless indifference to the value of human life. So while the advocate's claim is that the death penalty is unconstitutional, the Supreme Court has found that it is constitutional. The advocate's second claim is that the people who are executed may be innocent, but this is irrelevant after considering the advancement in technology we have today. The first point that the speaker makes about this claim is that the death penalty is murder, and murder is defined as the unlawful premeditated killing of one human being by another. So in this case, death penalty is technically not murder. The advocate goes on to describe the case of Johnny Frank Garrett, who was wrongfully accused of raping and murdering a nun in 1981. According to the Blum Legal Clinic from the Northwestern University School of Law, the pathologist hired by the prosecution testified that semen was recovered from Sister Benz's body, but he could not test it with the equipment he had and discarded it because no one had instructed him to keep it. And this just demonstrates that at the time of the case, the technology that they had was not as advanced as today. They could not take this piece of evidence and analyze it as they would have if they had the evidence today. And the fact that the actual criminal was found 12 years later through DNA testing shows that the technology we have today will help to prevent people from being, innocent people from being executed in the future. According to Bruce P. Smith for the Hastings Law Journal, 23 wrongful executions out of the roughly 7,000 state-sanctioned killings conducted since 1900 still represents a 99.67% success rate. And so though there have been innocent executions in the past, with the technology advancement that we have today, that small number of innocent executions will not increase. The third claim the advocate makes is that the death penalty uses substantial law enforcement resources. However, the advocate does not demonstrate how the death penalty does this. He lists the series of trials needed for the death penalty system, but does not compare this system to any other types of system or how these trials in specific affect the resources of the court system. Along with this, the advocate does not give an explanation as to whether there is a limitation of the resources of the court. And so though he claims that the death penalty system clogs up the federal court system, he gives no evidence for this. In conclusion, the claim that the death penalty is unconstitutional is false, and the advocate gives no explanation as to how it violates the Eighth Amendment. Second, the claim that people who are executed may be innocent is irrelevant because of the technology we have today that will prevent this. And third, the advocate does not give sufficient evidence as to how the death penalty clogs up the federal court system, and so does not support his main claim that the death penalty is counterproductive. Thank you.
All right, the structural stuff is all fine. You label the prime and secondary issues very clearly. On the first point, you challenge the advocate's evidence and whether or not it's adequate. And then you have a very effective counterclaim that says basically the Supreme Court has upheld it in numerous cases, although it restricts it in other cases, which seems to give us a comparable standard about whether or not it's constitutional that is probably the most effective one that you can use. On the second point, on the issue of innocence, the argument about technology reducing this chance, I think, is pretty effective. You do kind of try to mitigate the example that the advocate presents by suggesting it's simply a passage of time that resulted in, or that it's an earlier time that resulted in the fact that we could not test that kind of evidence. And now today, of course, the argument would be that that's pretty standard operating procedure. I would suggest that there might be some evidence or some information that shows that the courts, for instance, are pretty stringent nowadays in allowing executions to go forward if there is this kind of evidence that would mitigate somebody's guilt. I would suppose that if there was evidence that corroborated that a person's alibi or that denied their culpability in a particular situation that was genetic in nature, that the courts would recognize it. And I think you could get a little bit more information on that argument. The minimization argument is pretty good. That we're 99.67% effective. The argument that 23 people have been executed out of 7,000 and those 23 were innocent, I think there is a presupposition based on the research that the scholar is looking at that particular point. I think there might be good reason to challenge whether or not those 23 even do exist. And then I think a follow-up argument here would be why that's an acceptable level of risk. Even if we do have 23 people who are executed, that not just the percentage being effective, but why, even though it's imperfect, it still is worth having. Although we are getting a little bit into a value argument on that point, you've kind of mitigated the argument to some degree. And on the third point, I think that you have reasonable challenges on the advocate's lack of evidence or the way they're reasoning in which the court trials add to the costs. That's fine. I thought you had an excellent summary at the end of the speech. Thank you.